Welcome to the Probate Nation. My name is Richard Ruddy, and I am the host of the show this evening. Probate is a process to transfer title or ownership of probate assets to the beneficiaries of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. In order to start the probate journey, someone needs to be in charge of driving the probate train. The title conferred on that person is typically personal representative, and they may be named in a will or volunteer to serve in the absence of a will. Regardless, that person is not empowered to drive the probate train until they are legally appointed to do so. Over the course of 2 shows, we will learn the nuts and bolts involved in probating an estate in the District of Columbia, beginning with the types of probate available. We will also review the role of the D.C. Register of Wills throughout this probate train ride, from the time you are legally qualified to act to when you wrap up the estate and distribute all the assets to the beneficiaries. And we will highlight important duties and deadlines to keep in mind during the course of your journey. And in the second show, we will take all of this information and apply it to some typical estates so you can see how it fits together. With us tonight are 2 D.C. probate attorneys who will share their expertise and guidance on this topic. Our first guest is a probate and real estate attorney who practices in the District of Columbia and Northern Virginia. He handles guardianships, conservatorships, wills, trusts, foreclosures, estate administration, and real property litigation matters. He's a member of the D.C. Superior Court Fiduciary Panel and accepts court appointments in guardianship and estate matters. Prior to practicing law, he worked as a financial analyst and distribution manager for a Fortune 500 company. Our second guest is a partner with the D.C. law firm of Tobin, O'Connor and Ewing, P.C., where she focuses her practice on estate and trust planning and administration, probate, guardianships, nonprofit entities, real estate, and business law. She is also a member of the D.C. Superior Court's Fiduciary Panel and accepts appointments in guardianship and estate matters. And she is co-chair of the steering committee for the Estates and Trusts Probate section of the D.C. Bar. Please welcome D.C. attorneys Ray Johnson and Jennifer Consino. Welcome, guys.
Thank you.
That was a lot. Well, you guys have a great background. Holy smokes.
Yes.
Pretty busy.
So happy to have you with us today. You know, Ray, one of the first things that come out of the gate as we start to talk about probate, of course, is trying to figure out whether or not there's a will or not. Okay, so if there is a will in D.C. and we want to probate, how do we get that probate started?
Well, first of all, Richard, understand from the court's view, the will is like a roadmap for them in regards to what should be done in terms of where the assets should go. That's kind of a roadmap for them. Mm-hmm. Now, you can submit and file that will with the District of Columbia's Register of Wills at the time it's done and written, but that's not required. They typically don't want to hold a repository of wills because things can change.
Sure.
So typically at the time of death, what one would do is take the original will to the D.C. Register of Wills and file it and receive what's called a certificate of will.
Okay. And
then once they get that certificate of will, it will be assigned a number. Typically for today's date would be something like 2018 WIL ABC.
Okay.
And once it's filed and you've gotten your certificate, then I think you're ready to move on to probating the estate. The map is there for the court in case there's any problems, and then they will match the will up with the probate number in the administration.
Okay, that's a good. And then of course, if there is no will, is the process a little bit different as far as getting started?
Yes, it is a little bit different. If there is no will, you will not receive a certificate of will because none exists.
Okay.
And so that's called an intestate.
Okay.
I mean, without a will. Mm-hmm. And essentially the first step is going to the probate division and filing your petition for probate to get the administration started.
Okay, that's good to know. Now, a lot of people put their wills in a safety deposit box. How do we get that will in order to be able to take it down to the courthouse?
Typically, you have to have what's called a special administrator assigned and appointed by the court. Mm-hmm. And typically, that special administrator will have specific orders and authorizations to do what you want to do. That court order would give the bank the authority to provide that will to the special administrator under that court order.
Okay. So just to continue with that thought process, Jennifer, if there is no will, that's called intestate?
Intestacy
Okay.
in the District of Columbia.
And what does that mean?
That, at its most basic, means somebody died without a will.
Okay.
And so when that happens, the DC Code steps in and decides who is going to receive the estate.
So that code then determines who the heirs are in order to receive those resources.
Correct.
Okay, so that can be, that leads us into our next thing is, is kind of figuring out, identifying and locating all these beneficiaries or heirs. So talk a little bit about that, the importance of how we do that, how we go about doing that.
Sure. In intestacy matters, it's very important to figure out who the heirs are because they have a right to receive the assets. And the petition for probate in DC is very good. The page that talks about heirs actually says, is there a spouse? If yes, go to the next section. Are there children? Are there grandchildren? Have anybody passed away? Those heirs are entitled to notice of the estate administration.
So that's an important thing. We want to make sure we can identify who would be the heirs so we can actually let them know it's happening.
Exactly.
Okay, that's important. Now, what is some of the best ways for us to locate beneficiaries or heirs? Is there any particular strategy that you suggest?
So a couple of things we do is we use LexisNexis as they have a people search program that has proven to be very successful.
Okay.
And then the second way is the old-fashioned word of mouth. We talk to at least one of the heirs, and then we're able to start going down the list and do a family tree.
Well, that's very helpful. So if it turns out that those are not successful in uncovering the heirs and beneficiaries, do you ever use third-party search firms?
We do. We try to avoid it because they can be expensive and sometimes time-consuming. But we've used third-party search firms as well as genealogical professionals.
Okay.
Who've proved very successful.
That is a special skill set, there's no question. Well, Ray, let's take a look and talk about probate options that are available in DC. Give me the big picture, what are the options that I would have available to me in probating estates in DC?
Well, I would say the big picture is twofold. Number one, is it supervised by the court in terms of all of the filings? Or is it unsupervised, which requires primarily just filing the petition and a publication?
Okay.
And then the second big picture is it abbreviated versus standard, which is similar to the same. Abbreviated means you're not required to file any of the accountings. You're not required to file any other of the documents except for the petition for probate and the publication. And as things continually smooth in that respect, you will stay unsupervised unless someone objects.
Okay.
Now and then there's standard probate. Standard probate means essentially if someone that's not in a direct heir or beneficiary of the estate wants to have the estate probated, then they will go with a standard probate, which is typically supervised by the court, requiring all filings to be filed with the court.
Okay. Now, Jennifer, let's talk, if we don't, sort of like coming out of the gate, is there a small estate option in DC?
There is. The District of Columbia allows a probate of a small estate if the value of the assets is $40,000 or less.
Okay, let me make a note about that. Sure.
So the issue here, though, is when you go into probate, you need to have the list of the exact asset as well as all of the debts and expenses. They will want to see the funeral bill, other bills, and you will walk out of there with a court order stating specifically, you can close this bank account and pay these bills.
Oh.
So it's rather limiting in a way. If you uncover an additional asset, you would have to go back into the Register of Wills office.
Yeah, that is kind of onerous at the early to know that information all at one time.
So I'll be honest with you. I typically go the regular probate route, even if a small estate would be appropriate, just because of the constrictions.
Okay.
It seems that an asset is always uncovered later.
Okay. Well, that's good to know. Now, we're always concerned about bonding. So when does bonding become important in the options that we talked about here that Ray just mentioned that you're talking about?
So if a person passes away with a will and the will waives bond, you don't have to worry about bond at all.
Okay.
if the person passes away intestate without a will, you may still need bond. A way to waive the bond requirement is if all of the heirs sign forms that state no bond is needed. That doesn't always happen in DC. Sometimes there's disgruntled heirs that don't like a sister, brother, aunt, uncle, cousin. So you might have to bond for just that person if they refuse to waive the bond.
And the bond we're talking about, just for our viewers' purposes, is a bond that actually is underwritten by an insurance company.
Correct.
And so basically they're standing behind you. And so not everybody can be bonded. And so one of the big things to keep in mind, I guess, when we start the probate process, if you're going to have to get a bond, you better make sure that you're able to be bonded.
That happens frequently where people petition for probate and are told by bonding companies, we can't bond you. We've also seen as a practical matter, not a legal matter, that bonding companies don't want to bond people that don't have attorneys assisting them in administering the estate.
Yeah, very important. We're going to come back to that. I think that's an important point to bring out. Now, Ray, let's turn to the office that actually oversees this whole process at different levels of degree of review, and that's the role of the Register of Wills. So can you explain the organization of the Register of Wills and how they are involved at the various stages of the estate administration?
Yes, I can. I'm going to say there's three primary areas in the Register of Wills. There's the probate clerk's office, which essentially takes in all of the filings and all of the documents to get your process started.
Okay.
There's the legal department, which has a legal oversight in regards to approving what you have filed and make sure it meets all of the code, all of the regulations. And then there's an audit department. That's after the fact. Once your administration has started, then if it's a supervised account and it must be filed, then the auditor must approve your accounting. So those are the three primary areas: the clerk area, the legal department, and the audit department.
Okay. So as we go along, so at the after probate's been initiated, talk a little bit about how they're involved in overseeing the estate if it happens to be supervised.
Yeah. Well, after it's initiated through the legal department, essentially any filings that you make will go through the probate clerk's office. Now, if you are a fiduciary panel, those filings typically are what's called e-file nowadays.
Okay.
But if you're a lay person and not affiliated with the court in any way, you can paper file those. That could be anything from the publication. That could be anything from the accountings. But typically the accountings are required to be filed in person. And so they're just an overseer in regards to making sure that you're meeting the timelines that's required in the administration of the estate.
Okay. Well, that's something we want to talk to. Jennifer, let's talk about, before I go there, Ray, when we get ready to wrap up the estate, how is the Register of Wills involved with that?
Well, when you get ready to wrap up the estate, it all depends on whether it's unsupervised and abbreviated versus supervised and standard. Unsupervised, abbreviated, the wrapping up the estate happens automatically. Okay. In other words, on the abbreviated estate, you have 3 years from the beginning of initiating the probate petition to wrapping it up, getting all the assets distributed, because at the end of 3 years, it automatically closes in the courts. Now, if you have a situation where you have to get an extension, then you might have to file a petition to have it extended, and they would do that an additional year for you with a review by the court.
Okay.
In regards to the supervised standard probate, the way you wrap it up is that you get your final account approved by the auditors. And essentially that final account in all essence would show that everything that came into the estate was distributed out of the estate properly, and that's my final account.
Okay. Okay. Good to know. All right, so that shows their office. Jennifer, let's turn to the actual personal representative themselves. And this is, for many people, it's a one-time. You're only going to do it one time, or 2 times, and if they do it the second time, they must have had a good experience the first time. What are some of the important duties that all the PR should be aware of?
Well, the most important duty is they're supposed to marshal the assets. Now, that's a legal term, but that means identifying the assets, taking control of the assets, making sure they're safely administered. They also need to apply for a federal tax ID number. Okay. So the estate is a separate entity. It has to file its own tax returns. It has certain filing responsibilities when it makes distributions to beneficiaries.
Okay.
The personal representative must also have a receipt for everything that comes in and everything that goes out. When you file the accounting Ray was talking about, you have to supply the auditor with copies of every statement and every receipt to show where every penny went. That's very important.
And from that standpoint, if we have a bank that produces copies of the checks you wrote, that will generally be sufficient?
That will be sufficient. And actually, the court recently has been okay if you make a copy of the check before you send it out.
Oh, good.
They're able to then match it up on the actual statement. They can see check 303 cleared.
Oh, that's really very helpful.
Yes.
Because sometimes we get banks that won't give you the checks the way you need them.
Or they charge a fee.
They charge a fee, and then it becomes more expensive. I know we're going to talk about this in more detail a little bit later, but how about responsibility dealing with real estate for the personal representative? Anything special you want to mention about that, at least at this stage?
Sure. I think a lot of people forget that real estate is probably the biggest asset in the District of Columbia. The values are just booming. It's very important to keep insurance on that property. It's very important to make sure you don't turn the water and the heat completely off.
Right.
There's going to be floodings and pipes bursting.
Yikes.
And yeah, that's not good for the estate or the personal representatives.
Okay, absolutely true. Absolutely true. Those are all good things. Now, Ray, I'm going to turn to you for a second and talk about timelines and important deadlines. I know you mentioned a couple of those, but let's just kind of hone in on those again. So for an abbreviated, unsupervised probate, I know these take different rates. What are some important timelines in there?
Well, like I mentioned initially, the most important timeline is when it terminates. But one of the timelines is associated with the publication. You must have your publication done, I think, within 60 days of your appointment. And then after that, once your publication is done, that announces to the world that this administration has started, and your creditors now have their 6 months in order to file their claim against the estate.
Okay.
So then at that point, after 6 months, you'll know whether you have a valid claim or not against the state that must be honored.
Okay.
Once you go through the process of honoring those claims and satisfying those, again, one of the last important thing about a abbreviated is it automatically closes at 3 years, and you must take care of everything at that point in time.
Okay. Okay.
For the supervisors I mentioned, and as Jen had talked about, the very first step, even prior to accounting, is the inventory. As she mentioned, you got to marshal all of your estates. What are we working with, essentially, in regards to the assets? Once you have that starting point with the inventory, the accounts move from there. As money comes in and as money goes out, every 9 months, if it's a standard supervised account, you must file it with the Register of Wills Auditing Department, which must approve it.
Okay.
And then at the end, as I mentioned, once you've gotten everything in and everything out, the audit department will at that point in time do a final account and approve it, and then you can close down the estate and terminate the appointment of the personal representative.
How quickly do they normally respond to the final account and give you a sign off?
I've seen within 60 days.
That's
typically.
That's pretty good.
And essentially what happens
that's very
though is
good.
once you've done the final account and they approve it, then it goes to the judge who issues an order approving the account. And they typically take the word of the audit department.
60 days is very quick. Are there any possible consequences for failing to meet the timelines or deadlines with the court and these filings, of these, especially the accountings, I think?
There are some serious consequences. Yes. Essentially, you go before the judge. They will, if you're not meeting their deadlines or adhering to their requirements, they will issue a petition to have you go before the judge and explain why.
Okay.
And so those are the primary consequences that you don't want to be involved with.
One of the side notes to that is if the beneficiaries are upset, they can ask the court to convert an unsupervised estate into a supervised estate because the personal representative isn't meeting these deadlines.
Yes, that's it. I remember you guys mentioning that when we were preparing for the show. So you like to go simple, but if someone's not happy or someone gets mad at someone over Thanksgiving dinner, next thing you know, you've got a supervised probate and all the oversight.
And more expense.
Yes.
And what's important about what Jen is saying is that although it's unsupervised and although you don't have to file the accounts, it is very, very important that you do provide the accounts to the interested persons. It's very important that you do that in case there is an objection to anything. Then you have your roadmap and you have your detailed documentation about what has happened versus not doing an account and then you have to start over from the beginning.
So that's an important thing you bring up.
It's very important that you continue to supply the accounts to the interested persons, even though you don't have to file it with the court.
Communication. I think Jennifer had mentioned that as we were talking before we started the show, that that's one of the hot spots that can get you in trouble.
Yes, it can.
Because secrecy breeds concern. So, Jennifer, let's take a look a little bit about one of the processes we got to do is once we marshal the assets, we got to pay all the bills. Okay.
Exactly.
So we got to deal with creditors. Tell me, how do the creditors know that someone has died? They need to submit their claims, and do they have a time frame they have to do that?
So the personal representative, if they know about a creditor, they're supposed to provide notice to the creditor to say you have 6 months from the date of first publication in order to make a claim.
Okay.
A lot of the creditors also look through newspapers and try to find obituaries and see who's passed away. And the docket in DC is online, so some creditors once in a while search the online docket.
Interesting.
So they will make a claim. They would then have a time period, the personal representative would have a time period to say, that's a valid claim, that's not a valid claim.
Okay.
And I would say a majority of the time they're valid claims, and it's not worth the time and the effort to fight them because they are valid claims. But the personal representative can say no, and that's called a disallowance of claim.
Okay.
And then the creditor would actually have to sue the estate and go
Okay.
after the estate for the claim.
So when the claim is, do they file the claim initially directly with the personal representative, or do they file it with the DC Register of Wills?
They have to either file it with the court with a copy to the personal representative or vice versa.
Okay. Okay. And if this is a 6-month statute, so if they want to pursue it, they have to, if it's not agreed, they have to file their claim in court and that will then toll
File
the
a
statute.
complaint, yes.
Toll the statute. Okay.
Yes.
Okay. Well, that's important because then creditors they want to get paid, and that's one of the obligations of settling up the estate.
And one of the important things about, in terms of definition of creditors who are required to receive notice, I think the number is anyone that's owed $500 or more is required to receive notices all the time. However, you should pay all creditors off, but those below 500, you're not required to give them notice.
Okay, that's good to know too. Well, look, I know we got a lot to cover. This is our first part of a 2-part show, but I wanted to kind of give you guys an opportunity to share some final thoughts as we've covered in the material we've covered for this show. So I'm going to turn to you first, Ray, and anything you want to share about this part of the show.
Well, I think the important thing that I've heard and important for everyone out there is communication. Communication not only with the interested parties and the heirs and the beneficiaries in terms of what you're doing and how you're doing it with the creditors, but also communication in a timely manner with the Register of Wills in terms of your filings, in terms of your petitions that you're filing and requirements. So I think the communications on both sides is very, very important, that you keep everybody in tune about what you're doing, because what you don't want is anyone objecting and causing you to go before the court in terms of any unsatisfactory situation.
Okay. Jennifer, how about yourself? Anything you want to share at this point in the process?
So I think in DC we have a very helpful Register of Wills office. They are actually opening a self-help center for the pro se litigants. And every form is on the website. If you Google Probate Division, DC Superior Court, every single form will be there. They also have videos talking about all of the process and booklets that you can download and utilize. So don't feel like you're alone. There is help from the Register of Wills office. They can't give you legal advice, but they can give you information.
I will comment that I found that website was very robust. I was telling Ray about my experience going on and looking at that. They have a lot of material there, and basically broken down in digestible pieces for what applies to you. So I think that they've done an excellent job. I'm sure with the help of the DC Bar and probate section. Well, Jennifer and Ray, I want to thank you guys for coming in and having taking the time to talk to us in the first part of this show about an overview of DC probate. It's been very, very helpful, and it's going to be a great service to the folks in the District of Columbia. So thank you very much.
Thank you.
You're welcome.
You bet. You know, without a doubt, probate can be complicated and confusing. Our guest tonight touched on the initial steps you will need to take and stops you will need to make at the outset of your DC probate journey, including determining if the decedent died with a will or without a will, the importance of identifying the beneficiaries of the estate, probate options available, the role of the Register of Wills, duties of the personal representative, timelines and deadlines that you need to meet, dealing with creditors, and all very, very important and helpful information. Be sure to check out all of the useful guides, forms, and checklists available online from the DC Register of Wills, and we're going to show that website on our screen. But there is much more to do as you continue your DC probate train ride. I encourage you to watch the next show as our guests, attorneys Ray Johnson and Jennifer Casino, complete the overview of the DC probate process when they will discuss wrapping up the estate, fiduciary compensation, common problems encountered in the estate administration, the importance of getting advice from professionals, and then they will apply all of that has been discussed to some typical DC probates. This brings us to the conclusion of our show today on Overview of DC Probate Part 1. Hope you found it informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.